Well, the saga involving San Diego Mayor Bob Filner shedding light on the issue of sexual harassment at the workplace. And joining us now is Los Angeles trial attorney Anahita Sedaghatfar, who specializes in these kind of cases. Anahita, thank you very much for joining us here in the KNX Business Hour. And tell us what some of the big takeaways here from what we've seen here in San Diego recently regarding this workplace incidents that have been widely reported and all the sexual harassment allegations that we've been hearing about.
Yeah, well, thank you for having me. It's my pleasure to join you. I think definitely what's been going on over here in San Diego has raised a lot of questions with respect to what are an employer's duty out here in order to prevent sexual harassment from taking place in the first instance. So, I've been getting a lot of calls from employers out there, even employers that have been in business for years, that are now starting to worry in terms of what their liability would be when some of their employees or managers or supervisors engage in this type of terrible behavior. Generally, California recognizes two types of sexual harassment. We have quid pro quo, and that's just a fancy term for, you rub my back, I'll rub your back. And that's usually when an employer or supervisor says to an employee, if you want a raise, you need to have sex with me, or if you want a promotion, take your clothes off. That's one form of sexual harassment that California recognizes. I think the more common type that we see, and what we've seen right here in the Filner case, is what we call hostile work environment. And that is when a manager or supervisor basically creates a work environment that makes it hostile, that it makes the terms and conditions of an employee's work hostile, and it makes it hard for them to come to work. So I typically advise my clients who are employers that they need to take whatever steps they can to prevent that type of harassment from occurring in the first instance. I think prevention is the best tool for employers, not only from a moral standpoint. We know that, morally it's wrong. Every employer has a right to work in a workplace free of any type of harassment, but also from a financial perspective. Because in California, and I don't know that many employers know this, employers can be what we call strictly liable for sexual harassment that takes place on behalf of their managers or supervisors. So what that means is they might not even know that their supervisor or manager is engaging in any type of bad conduct, and they're still going to be liable for damages in court.
As far as prevention is concerned, would you recommend every company have some sort of course or orientation on these issues?
Absolutely, 100%. And well, under California law, employers who employ 50 or more employees have a duty to provide training, 2 hours of training every 2 years for their managers and supervisors. They also have to post certain posters in their workplace that set forth the harassment laws. What I advise my clients to do, though, is really to have an employee handbook. Have an employee handbook and also make sure it's up to date. The laws are constantly evolving and changing. So in that employee handbook, I think that the employers really need to set forth what the employee's rights are. Make sure that they understand that they have a right to work in a workplace free of harassment. Tell them who they can report that harassment to. Oftentimes, employers will have a human resource department or will have some type of supervisor that they can go and report their complaints to. That's very important. And I think, most importantly is take the complaints seriously. Investigate any employee complaint of harassment. Interview witnesses. Do what you need to do to make sure that particular claim is looked into properly. And of course, if you find that there's merit to any type of harassment or any of these types of claims, an employer has a duty to remedy it. They need to stop that harassment from taking place. And whether that is firing the individual that's responsible for the harassment, demoting him, putting him on leave, there's no exact standard. It really depends on the circumstances. But the employer needs to do what they can in order to stop that from taking place. Otherwise, they face hundreds and thousands of dollars in damages.
Los Angeles attorney Anahita Sedaghatfar, trial attorney here in Los Angeles. Thank you very much for sharing your expertise with us here today in the KNX Business Hour.